Chutney. When we hear this word, it invokes nostalgia, the tangy taste, and something which is mouth-watering. This one chutney, which allegedly is not a chutney. Schezwan Chutney. Is it a chutney or a brand? Let's talk about this. Now, before we go into this topic, it is very important for me to put a disclaimer. Hi, I'm a lawyer, and as of today, I represent a party which is in direct dispute with a company which owns the trademark Schezwan Chutney, like it purportedly owns this trademark. However, I'm not taking any sides. I'm just trying to make this video for educational purposes. Now, let's get back to the video. Now, as I said, there is a company which owns the trademark Schezwan Chutney. It's Capital Foods Private Limited. It also owns this famous brand Ching's. But Section 9 of the Trademark Act clearly states that if a name describes a product, you cannot get the trademark for that said product. You cannot get trademark computer if you sell computer. You cannot get trademark oil if you sell oil. One may ask this question, what about Apple? But Apple doesn't sell apples. So the main issue here is, how come Ching's own this trademark Schezwan Chutney if it sells Schezwan Chutney? Or does it sell Schezwan Chutney or some random chutney? And what happened to those companies which tried selling Schezwan Chutney? Now let's start with this question. What happened to those companies which tried selling Schezwan Chutney? In year 2020, Ching's sued Damai International for purportedly selling Schezwan Chutney. Let's call this their first suit. This matter came before Justice J.B. Kulabawala in the Bombay High Court, and Bombay High Court granted ex parte injunction against Damai International, restraining them to use this mark Schezwan Chutney. Now they cannot write Schezwan Chutney in their bottle and sell what they wanted to. Again, in the year 2020, Ching's sued this other company called Puniraj Foods, again for selling Schezwan Chutney. It again came before Justice J.B. Kulabawala, and again Honorable Bombay High Court granted ex parte injunction against Puniraj Foods. Now there were two ex parte injunctions from Bombay High Court in the same year. Just in case if you do not know what ex parte injunction is, the court restrain you from doing something or not doing something. And because it's ex parte, it means you didn't even know that such order came. Because while passing ex parte injunction orders, court do not hear what is the story of the other side against whom such adverse order is being passed. So there is that, the ex parte injunction. Now, Ching's filed another case in the same year against Earthly Joy for again purportedly selling Schezwan Chutney. This time, matter came before Justice G.S. Patel. He denied granting ex parte injunction. He was of the opinion, let's issue notice, let's hear what is there for Earthly Joy to say before passing any adverse order. Earthly Joy claimed that they have been using this mark Schezwan Chutney way before that Ching's is claiming that they have invented this word Schezwan Chutney. And secondly, they claim that how the hell someone could claim monopoly over such a descriptive mark Schezwan Chutney. This will stop anyone from selling Schezwan Chutney because they have to write what is they are selling, right? Schezwan Chutney. So that's what their argument was. Till now, there has been no injunction against Earthly Joy. Now, this purportedly was the first time there was no ex parte injunction in favor of Ching's in Bombay High Court. But again, there were companies which were still selling Schezwan Chutney, and they had to do something against them. So in year 2020, Ching's did find one company, which is Food Rights Schezwan Chutney. So let's call this the fourth suit. But this time, it was not filed before Bombay High Court. It was filed before Honorable Delhi High Court, and this matter came before Justice Mukta Gupta. Delhi High Court rejected the prayer of interim injunction and held that this mark is descriptive. You won't be getting an injunction for this mark, and nobody could claim monopoly over the same. Though it is pertinent to note that there was injunction against Mrs. Food Right for the trade dress. The trade dress, the court was of the opinion that the trade dress is similar, and that's why there was the injunction, but there was no injunction per se for using the word Schezwan Chutney. And again, this observation came that Schezwan Chutney is a descriptive mark, and this was a problem for Ching's. Ching's immediately filed an appeal before the Honorable Division Bench of this Honorable Delhi High Court. This matter came before the then Chief Justice, Justice Dhirubhai Patel and Justice Jyoti Singh. Now, this division bench directed the trial court to expeditiously decide this matter without overruling this fact that the trial court held that this mark is descriptive. So the matter came back again to the trial court to decide this expeditiously. Accordingly, the trial court, by judgment dated 11 January 2023, again held that this mark is descriptive and no one could claim monopoly over the same and the injunction will not be granted, for which Ching's again filed appeal before the Honorable Division Bench, and as of today, this appeal is still pending. So now, there is no injunction in Bombay High Court, and there is no injunction in Honorable Delhi High Court. There are two courts where there is no injunction for this mark Schezwan Chutney. Now, while all these proceedings were going on, Ching's found these two more companies which were selling Schezwan Chutney. One was Melting Point and second was Majithia Masala. So, in this fifth and sixth suit, what Ching's did not inform to the Honorable Court that there has been any unfavorable order against them in Bombay High Court and Delhi High Court. They just showed the favorable order that till they have gotten against the companies which have been using Schezwan Chutney. So, court accordingly passed the order restraining these two companies, Majithia Masala and Melting Pot, while these different cases from using the word Schezwan Chutney. Now again there was an ex parte injunction in favor of Ching's. Ching's then filed its seventh case against Viva, but this time at the District Court of Goa, again for selling Schezwan Chutney, and again got ex parte injunction, and this time as well Ching's did not inform the court of the orders which were against it and only relied on those orders which was passed in its favor. Viva then approached Honorable Bombay High Court, while filing an appeal, and vacated that injunction, reversed it. So now Ching's got unfavorable order from Bombay High Court, Delhi High Court, and Bombay High Court at Goa. Here comes the final suit, the eighth case. Ching's sued Swad again for selling Schezwan Chutney, and this time it again went back to Nashik District Court, and again this time obtaining ex parte injunction, and again this time the Ching's did not inform the Honorable Court about the unfavorable orders which were passed against it. Now Swad filed an application to vacate this injunction, this ex parte injunction passed against it, which is as of today is pending. Swad also filed an application under section 124 of the Trademark Act seeking permission of the court to let them file a cancellation petition, a petition to cancel the trademark Schezwan Chutney on which they have been relying till so far, stating that they are party aggrieved. Court found out that there is a prima facie case, there is a tenable case, and then allowing Swad to file a cancellation petition. However, Swad sought this permission that they file this cancellation petition at Honorable Bombay High Court, considering that Bombay High Court would have the appellate jurisdiction over the Nashik District Court, which made sense back then. However, there was this one case which was going on in the same period. Justice Hari Shankar in Dr. Reddy's case held that if a dynamic effect of a trademark registration could be felt somewhere, such aggrieved person could approach that respective High Court, which in case could be Delhi also, if they have substantial sale in Delhi, which they did. So, Swad approached Honorable Delhi High Court, filing cancellation petition against Ching's for the trademark Schezwan Chutney, claiming that Schezwan Chutney is a descriptive mark. How the hell one could claim monopoly over the same? So here I, along with my colleagues and senior, are representing Swad at Honorable Delhi High Court. So what we did in that case, that we found a flaw in the registration of this mark Schezwan Chutney. So see, when you apply for a trademark, registry might have some objection. Registry might be of the opinion that this mark cannot be trademarked, considering it's a descriptive mark. So trademark registry could object to the same, for which you have to file a reply to the examination report satisfying the registry that your objections are futile, it's wrong, it's erroneous, and let them have that mark registered. You might have a hearing as well to satisfy the registry. But in this case, what happened that there was no reply to this examination report, there was no hearing, and directly the mark get advertised and then later registered in the name of Ching's, Capital Foods Private Limited. We also showed that FSSAI categorized Schezwan Chutney as a broad food descriptor, a food category, and there were other averments as well. While it's pertinent to note that Ching's also took some strong stances in their past proceeding. They claim that the mark Schezwan Chutney is their invention. They have invented this word, this combination, Schezwan Chutney. Before that, it never existed. That's what invention is, right? So what do you think? Schezwan Chutney, is it a brand or a chutney?